Hello, this is Attorney Farrah. Have you been worried about this pandemic and are concerned about estate planning, drafting your wills or trusts or powers of attorney? I can't tell you how many questions we have been getting about this particular issue, and it has been tremendously surprising, but also completely necessary in a way to educate everyone on the tremendous need that there is for estate planning. Now, I would say this regardless, whether there's a pandemic or not. So obviously, if there's a pandemic, you don't need to be worried so much and scrolling mindless through the news and media and getting more and more concerned and having some sort of doomsday concern about this thing. What you should be really doing is trying to figure out a way to be as productive as possible. And one of those things is to take this time to get yourself organized and to ask yourself some difficult questions. Those questions are things that if you are married, that you would sit down with your spouse and actually discuss with them. Questions like, who is going to take care of your children if something were to happen to you? How would you like your assets to be distributed? Who will be making medical decisions on your behalf? Who would you like to go to the bank, open up a security deposit box for you, sell your property, pay your bills? Who do you trust with your social security number and all of that private information? Who will take care of those things in case you were to become incapacitated or seriously ill? Those are obviously serious questions and not a lot of questions that people like to think about or ask. And under normal circumstances, nobody wants to think about that. And under a pandemic, again, people try to put it off. But I have gotten so many questions throughout these last few weeks from people who have been so concerned and so scared because they watch the news and then think that they now have to protect their families and really check this off their list. And I would say that don't do it out of a place of fear, but do it out of a place of love and concern for your own family. And also understand that just because you are signing something doesn't mean that you are putting bad vibes into the universe. Sometimes I get people and they say, well, I don't want to think about it because that means that I have to think about all these bad things. The thing about it is that it's an inevitable fact of our life, and it's something that we do have to prepare for and plan for. And the responsible thing for all of us to do is to plan for it now when we're healthy and we're able and we're capable of doing so. So let me just go through a couple of questions. There's something going on with Facebook where I can't see all the questions immediately, but I'm seeing them as private messages. And even now I'm getting a few questions that I'll answer. For example, the one question that I'm receiving is, if we are married, do we still need to do a power of attorney? Wouldn't my spouse immediately become my power of attorney? And the answer to that is no. I know that that's a very common misconception. A lot of people think that if you're married, that means that your husband or your wife will immediately become your power of attorney, and that's simply not true. In a healthcare facility, it may or may not be that case, but there would most likely be some confusion that you would like to avoid in an emergency situation. However, in a property power of attorney, your spouse can't just simply walk into a bank and say, oh, my spouse is injured or seriously injured, and because of that, now I need to go into his or her safe deposit box, or I need to open up a bank account for her, or I need to take out everything. It doesn't work that way. So we need to have something in place to make sure that that is taken care of immediately. And that is both a property power of attorney and then a power of attorney for healthcare. You do the two together. I always make sure that we have both in place because one isn't going to be sufficient for your needs. So you do that, and then you can also do, on top of that, you can do a last will. A last will is something that you would have in place that would specifically say how you want your assets to be distributed in the case of your passing. And in that case, you name your children, or if you don't have children, then your next of kin or your friends or family members or whoever you're planning to distribute, you put it into a will. Now, most people that come into my office, they tell me that they want to get a will and they think that that's sufficient. But 9 times out of 10, just the way that their lifestyle is and the number of assets that they have, and I'm going to explain what assets are in a minute, that isn't sufficient. Because a will is actually a public document, It will not avoid what is called probate, which means that your beneficiaries may have to go to court in order to have all of the distributions enacted the way that you want to. And really, when you start talking to the clients, you realize that the main reason why they're coming to you is to avoid court or to avoid an extra hassle for the beneficiaries. And a will just on its own won't do that. So then you up your ante and you get what is called a living trust. And a living trust is a fantastic document that will include wills, living wills, as well as power of attorney. A trust allows you to handle things privately and confidentially. It also allows you to distribute to everyone that you want to, and it also takes care of a very comprehensive plan of how to do those distributions and under what circumstances to do them. So it is a much more important vehicle that saves thousands upon thousands of dollars for your beneficiaries because it avoids court and legal fees. And it allows for you to have a complete package available for whoever you designate so that they don't really have to do a lot of extra thinking. They just have to execute the way that you would really want them to execute, and you've already set it up. So a trust is a fantastic vehicle that a lot of people don't realize, because a lot of times, like I'm getting a question right now, that aren't trusts only for very wealthy people. And no, they are not. That is, I'm not sure where that came from. I think it's probably because people confuse that with like trust babies or trust fund children or something. But a trust is not that same thing. It's not for fabulously wealthy people. It's for regular people, especially designed if you have children or if you're married, but also for single people as well. And it is just a fantastic vehicle that will allow you to transfer things a little bit more seamlessly and comprehensively, and without any of the headache that you would want any of your loved ones to have to go through in a time of already, of crisis already. It's already an emotional time, and the last thing that you want them to do is then be sitting there worried about asset distribution and who gets what and how it's supposed to be, if it's supposed to go according to this way or that way. So those are the basics. And then I know that there's other questions here. Specifically, they're saying, okay, is a trust tremendously expensive to set up? A trust is definitely more expensive to set up than a will, but it's not tremendously expensive. There's a flat fee that's involved, and that flat fee is essentially a lifetime fee. You pay that one time. After that, in our office, you get a free 3-year review, and then your trustee, once both of you have passed away, gets a free consultation with us as well, so that we can go through everything and explain what his or her responsibilities are. So it's a one-time fee. You pay that fee, and you include everything. So we would walk you through every step, and we would handle all of it for you. So that means calling your banks, calling your financial advisors, talking to your accountants, talking to your the person who handles your stocks and bonds, and preparing the documents that we might need to transfer insurance. All of that stuff would be done within our office, and you really wouldn't have to worry about any of it. You would just get a complete package in place. I have a couple of questions here specifically about powers of attorney for healthcare. So a healthcare power of attorney is specifically only designed if you were to become incapacitated. Incapacity can be defined that you were unconscious, in a coma, and you are unable to explain your wishes to another person. Now, you don't have to be in a coma. It could also be if you had Alzheimer's, or you had some memory loss, or something that was barring you from making the capable decisions that you normally would do. And so a power of attorney would kick in. In most circumstances, you would name your spouse first, and then I always recommend that you name 2 other people beyond that, so that if your spouse isn't available, the next person in line, and then following the next person. And how do you decide these people? That's another great question. And I always tell people, you think about the person that you would trust the most, and that will stay calm and reasonable under any circumstance, and who will take care of you and your family in the best possible way. They do not have to have medical knowledge. They don't need to be a healthcare professional, because you're already allowing those decisions to be made by healthcare professionals. but it should be somebody that you trust implicitly and that you are more than happy to give over the reins to, and know that they will do what is needed in your best interest. And remember that whatever your specific requests or concerns might be, we can put those within any power of attorney, so that if you have specific detailed instructions, you can put those in as well. And then, you know, your agent has to follow those requests as well. So sometimes we'll see specific requests that, you know, I want to be in a certain room, and I want to make sure that I'm comfortable in this particular way, and I want to make sure that, you know, such and such people are allowed into the room. You can put all of that in there if you would, if that makes you comfortable. So I think there's a few other, there's a question here about the will again. So a will is a rather simple document. It's about 4 or 5 pages long, maybe even less. It's very simple. It kind of, you know, designates yourself, and then it says it designates who you want the your property to go to, and then essentially that's it. So it's a great starting tool, but it's not necessarily going to solve all of the questions that you have. So it's something that you should definitely have if you don't have anything else in place, but you probably would have to build upon that if that's the only thing that you have. So if you have further questions, I urge you to call us. You can call us at 630-504-0648. I just wanted to hop on here so I could answer these questions because I've gotten quite a few. We've been very, very busy handling estate planning, wills, trust, powers of attorney for many people. For healthcare professionals as well, we're offering reduced packages. And for anybody who is in the essential worker line, we offer that same discount. So if you want to give us a call, 630-504-0648. Thanks so much. Bye.